Hello everyone, welcome you all again to Namma LaExcellence Bengaluru. So we have already discussed 2021 Polity previous year questions. So today we are going to discuss 2022 Prelims Polity questions. Okay, so we will start with the first one. It is the 11th question. So this is about the Contempt of Court Act. So pursuant to the report of H.N. Sanyal Committee, the Contempt of Courts Act was passed. Second is the Constitution of India empowers Supreme Court and High Courts to punish for contempt of themselves. The Constitution of India defines civil contempt and criminal contempt. In India, the Parliament is vested with powers to make laws on Contempt of Court Act. So firstly, we have to know that in the year of 1961, this H.N. Sanyal Committee was formed, and this gave its report, and based on that the Contempt of Courts Act was passed. And here the Constitution of India empowers Supreme Court and the High Courts to punish for contempt of themselves. So this is the right option, because the Constitution under Article 129 gives this power to the Supreme Court to punish for the contempt of itself, and under Article 215 the High Courts will have the power to punish for the contempt of themselves, and that is why the Constitution of India will empower both Supreme Court and High Courts to punish for contempt of themselves. Third one is the Constitution of India defines civil and criminal contempt. So this you should know, that the Constitution of India will not define the civil and criminal contempt, rather it is defined by the Contempt of Courts Act of 1971. Make sure that in the Constitution usually there will not be detailed procedures, or you can say the definitions. Okay, so this is wrong. Fourth one, in India, Parliament is vested with powers to make laws on Contempt of Court Act. Yes, Parliament will have the power to make the laws on contempt of court, and that is why this 1971 Act was passed. Okay, this is also correct. So the correct option is 1, 2, 4 are the right options. Next one, with reference to India, consider the following statements. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. So here you'll have to apply your common sense, that why not the corporate lawyers or the patent attorneys be recognized as advocates? So they can also be recognized as advocates. So it is under the Advocates Act, of 1961, the one who will enroll as advocate, or the one who is enrolled as lawyer in the Bar Council can be recognized as a advocate. Okay, that is why it is not just government law officers and legal firms, even the corporate lawyers and patent attorneys can be recognized as the advocates. So this is a wrong statement. Bar councils have power to lay down the rules relating to legal education and recognition of law colleges. Yes, again under the Advocates Act of 1961, the Bar Council will have the power relating to rules for legal education and recognition of law colleges. So this is the correct option, and that is why option B is the correct one. Next question. Consider the following statements. A bill amending the Constitution requires prior recommendation of President of India. Okay, so this is a wrong statement. Under Article 368, a Constitution amendment bill can be initiated either in Lok Sabha or Rajya Sabha, but it does not require the prior recommendation of the president. So this is a wrong statement. Second, when a constitution amendment bill is presented to the President of India, it is obligatory for the President to give his or her assent. Yes, this is a correct statement, because under Article 368, when a constitution amendment bill is presented to the President, then he or she should or must give the approval. There is no other option. A constitution amendment bill must be passed by both the houses, that is Lok Sabha and Rajya Sabha, by a special majority, and there is no provision for the joint sitting. Yes, it is correct. So the 2 and 3 options are correct. So here you should remember, constitutional amendment bill requires approval of both Lok Sabha and Rajya Sabha with a special majority. So only under the case of ordinary bills, there will be joint sitting of the house. When it comes to money bill, money bill can be introduced only in Lok Sabha, and thus the approval of Lok Sabha is enough for a money bill. So 2 and 3 will be the right. So the next question, the Constitution of India classifies the ministers into 4 ranks, that is Cabinet Minister, Minister of State with independent charge, Minister of State and Deputy Minister. So here you might be in a confusion that yes, we do have all these ranks, that is cabinet ranks, Minister of State, Deputy Minister. Yes, we do have these ranks, but the thing is it the Constitution that classifies it? Okay, so this is a question. We might overlook this term, that is the Constitution of India. Okay, it is not the Constitution. It is by the administrative convenience and the convention that we divide the ministries into these ranks. Okay, it is not the Constitution. So this is a wrong statement. The total number of ministers in union government, including the Prime Minister, shall not exceed 15% of the total number of members in the Lok Sabha. Yes, this is a right statement. So this was through the 91st Constitution Amendment Act that the Union Council of Ministers should not exceed 15% of the total strength of the House. Yes, this is the correct statement. So only 2 will stay as right. The next one is, which of the following is or are the exclusive power of Lok Sabha? So here they are asking the exclusive power. The Lok Sabha will have the only power to do this, that is exclusive power. To ratify the declaration of emergency. So here you need to take care that the emergency can be ratified by both Lok Sabha and it should be ratified by both Lok Sabha and Rajya Sabha. So it is not the exclusive power of the Lok Sabha. Next, to pass a motion of no confidence against the Council of Ministers. Yes, as we know that the Council of Ministers are collectively responsible to the Parliament in general. Okay, in general they are collectively responsible to the Parliament, but in specific they are responsible only to the Lok Sabha, and that is why a no confidence motion can be passed only by the Lok Sabha. And okay, this is the exclusive power of Lok Sabha. Next, to impeach the president. Again here, to impeach the president, it can be done by both the Lok Sabha as well as the Rajya Sabha, and that is why this is not the exclusive power of the Lok Sabha. So the correct one is only 2 is correct. Next, with reference to the anti-defection law in India, consider the following statements. The law specifies that a nominated legislature cannot join any political party within 6 months of being appointed to the House. Here you should note that a nominated member can join, okay, he or she can join a political party within 6 months. Okay, it is within 6 months. Okay, not after that. So this is wrong. They are telling cannot join any political party within 6 months. Yes, within 6 months they can join. Okay, after that they cannot. This is a wrong statement. The law does not provide any time frame within which the presiding officer has to decide a defection case. Yes, this is correct. The presiding officer is the deciding authority, but in the constitution or in the law there is no provision that the presiding officer will have certain time limit within which he or she will take the decision. So this is a correct statement because there is no time limit. Okay, so only 2 is the correct statement. Consider the following statements. Attorney General of India and Solicitor General of India are the only officers of the government who are allowed to participate in the meetings of the Parliament of India. So here this is interesting to note that under Article 88 of the Constitution, it is the Attorney General who can participate in the meetings of the Parliament, be it in the committees or the parliamentary proceedings. It can be by the Attorney General only. Okay, not the Solicitor Generals. The Solicitor Generals are the law officers who will assist the Attorney General, and this is not a constitutional post, and hence they will not have any such constitutional power to participate in the parliamentary meetings. So this is a wrong statement. Then according to Constitution of India, the Attorney General submits his resignation when the government which appointed him resigns. So here you need to take care that you may overlook the according to Constitution of India sentence. Okay, you may see that Attorney General submits the resignation. Okay, so this will happen by the convention. Okay, it is not as per the Constitution. Okay, you have to read the statements carefully. It is according to the Constitution of India. This is wrong. Okay, it is not according to the Constitution, rather it is just a convention. So here neither 1 nor 2 will be the right one because both of them are incorrect statements. Next, with reference to the writs issued by the courts in India, consider the following statements. Mandamus will not lie against a private organization unless it is entrusted with a public duty. Yes, mandamus can be against a government body or even against a private body with the condition that this private body should be entrusted with the public duty. Okay, so this is a correct one. Mandamus will not lie against a company even though it may be a government company. Okay, this is again a wrong statement because a mandamus can be issued against a government company also. Then any public minded person can be a petitioner to move the court to obtain the writ of quo warranto. Okay, so here you should remember that the writ of quo warranto, in the writ of quo warranto, there is no need of locus standi. Okay, there is a relaxation with respect to the locus standi. That means it is not just the person who is affected, but any public spirited person can go to the court and they can obtain the writ of quo warranto. So thus 1 and 3 will be the correct options. Then with reference to the Deputy Speaker of the Lok Sabha, consider the following statements. As per the rules of procedure and conduct of business in a Lok Sabha, the election of Deputy Speaker shall be held on such date as the Speaker may fix. Yes, this is the right one. The Speaker's election date will be fixed by the pro tem Speaker, whereas the Deputy Speaker election date will be fixed by the Speaker. Yes, this is correct one. There is a mandatory provision that the election of a candidate as Deputy Speaker of Lok Sabha shall be from either the principal opposition party or the ruling party. So here you must note that it is just a convention. It is just a convention that the speaker shall be from the ruling party, whereas the deputy speaker shall be from the principal opposition party. So it is just a convention and it is not mandatory. Okay, that is why this is a wrong statement. Third, the deputy speaker has the same power as of the speaker when presiding over the sitting of the house, and no appeal lies against his rulings. Yes, it is correct. When there is no speaker, the deputy speaker will preside over the house and there is no appeal lies against his rulings within the house, because the presiding officer, okay, or the speaker or the deputy speaker who will act as a speaker, they whatever the decision they will take is the final. There is no appeal against their rulings within the house. Yes, this is correct. Fourth, the well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and is duly seconded by the prime minister. So this is absolutely wrong, because there is no such provision. So 1 and 3 will be the correct options. Next, in the Government of India Act 1919, okay, this is a British era law, okay, or this you will study in the historical background to the constitution. Historical background. So in the Government of India Act 1919, the functions of the provincial government were divided into reserved and transferred subjects. Which of the following were treated as the reserved subjects? So here you need to note that in the Government of India 1919 Act, the subjects were divided into the reserved and transferred. So like how in the present constitution, in the 7th schedule we have the central list, state list and concurrent. So the same was there in the Government of India Act 1919. Subjects were divided into reserved and transferred. So here you should remember the logic. The reserved were the ones which were reserved for the Governor General, or you can say the Viceroy. Okay, so these reserved subjects were the one where there is a involvement of power, where there is involvement of revenue. Okay, these were reserved for the Viceroy. Transferred were the ones, these were transferred to the local government, or you can say the regional government, and these were mainly for the people's welfare. So the subjects that are related to the people's welfare can be classified into the transfer subjects, such as the local government, whereas the reserved ones where there is money and power involved, administration of justice, land revenue and police, that is 1, 3, 4, these were the reserved subjects. Okay, next one is, if a particular area is brought under the 5th schedule of the Constitution of India, which one of the following statements best reflects the consequences of it? So we know that the 5th schedule will talk about the scheduled areas. Okay, scheduled areas. So where the tribal majorities do live in this area. So this is specific to the states which have the tribal regions except the northeast states, that is Assam, Meghalaya, Tripura and Mizoram. So except these, all other states which have tribal areas are classified as the scheduled areas under the 5th schedule. So what can be the consequence? First one, this would prevent the transfer of land of tribal people to the non-tribal people. Yes, this is correct, because the governor under the 5th schedule, the governor can restrict the transfer of the tribal land to that of the non-tribals. Okay, so this is the correct one. Second, this would create a local self-governing body. So this is not as per the 5th schedule, rather this is a provision of the Panchayat extension to the Scheduled Areas Act. Okay, so this is not the consequence of the 5th schedule. C, this would convert that area into a union territory. So just by using your common sense, you can say it is not correct. The state having such areas would be declared a special category state. Again, just by using your common sense, you can tell the C and D are absolutely wrong statements. Okay, so this is the end of 2022 PYQs of Polity. Again, I will come up with another video on 2023 questions. Thank you very much.